Hello, everybody, and welcome to our November Now What series program. You're in a dispute with your contractor. Now what? Joining us this evening is Nels Volin from Volin Wilkinson, and I'm going to let Nels take this over and tell you about himself and his program.
Thanks, Amy. Good evening, everybody. My name, as Amy mentioned, is Nels Volin, and I'm a partner at Volin Wilkinson here in Portland. A little bit about myself, very briefly, not to give myself a bunch of accolades, but you probably wouldn't be tuning in to hear an estate planning attorney or a family attorney or a criminal attorney talk to you about construction disputes. And fortunately, I am a construction attorney. That is all that I and my law firm do. Primarily practice in the area of construction defect litigation, although I handle a number of different types of contractor and owner disputes, almost exclusively on the side of the homeowner or the project owner in the case of an apartment building or a school or something like that. I've been an attorney licensed in Oregon since 2012. I'm also licensed in Washington State, but we're going to limit our comments to the extent that they're applicable to Oregon law to our state, Oregon. My firm practices all over the state of Oregon in almost every circuit court. And I've been doing this for about 10 years. And so I've been able to sort of see how things can unfold with contractors in ways that we wish that they wouldn't. I'm going to plan for my remarks this evening to last about 45 minutes. I'm going to reserve a little bit of time at the end for questions. We do have the question and answer function available, as well as the chat. You're welcome to use those to ask questions, and I'll answer those as they come in. Otherwise, feel free to chime in at the end. I'm also going to have my contact information available on a slide. If you'd like a copy of this presentation, I'm happy to send you one. Or if you have any questions or want to follow up with me this week after tonight's comments, feel free to do that. I'll have my email address and other contact information in the slideshow. So we're going to dive into talking about what it is that leads to me having legal work, which is disputes. And actually, my hope, not only for everybody who's on this call, but also for anybody out there, is that you actually don't need me in my representative capacity for a lawsuit unless it's absolutely necessary. I've represented in my career several hundred homeowners in residential construction claims against contractors. Without exception, all of those lawsuits could have been avoided if parties, both the homeowners and the contractor, had acted differently. So I'm going to try and not be focused on, well, what happens if you actually sue your contractor? We're going to be focused on how do you avoid having a dispute boil over into what is going to be, I promise you, an expensive and time consuming ordeal. And that's not to say that a carefully articulated lawsuit doesn't have its time and place. But as I mentioned a moment ago, the overwhelming majority of disputes between contractors and owners can avoid litigation if the parties take some proactive steps. So that's what we're going to focus on today. And I'm going to give you a fair warning. I have not done a webinar style presentation using this platform in a couple years. So if I have to jump out of my screen share to advance my slides, I hope you'll forgive me, but we're going to go ahead and start in here. So first of all, we're going to talk about what leads to construction disputes. And there's four general categories. They're here in the slides, and we'll talk about each of them briefly and then dive a little bit more in depth into each of these. But there's generally four circumstances that, in my experience, tend to lead to bigger disputes or lead to a dispute in general. The first is a lack of communication. I think you could pretty much argue that most disputes, from wars to divorces to contractor and owner disputes, probably boil down most often to either improper communication or, as I've phrased it, a lack of communication. We're going to talk a little bit about the best ways to communicate with your contractor. But certainly, a lack of communication is one of the leading reasons that people end up coming into my office and saying, hey, I need a lawyer to go after my contract. The second cause of disputes is a lack of due diligence. And here I'm going to go ahead and beat up on the very people that I typically represent and who I'm guessing are some of the participants in this call, which are the actual property owners. There are a number of resources that are available to owners to do research on their own to vet contractors. And a big part of this, it goes to matching what it is that the project owner, like the homeowner, wants to achieve by hiring a contractor, and then what that contractor can actually offer them. And I represented a very nice couple who made a very expensive mistake probably 6 or 7 years ago. They owned a home that needed to have a new foundation poured because they wanted to have a code compliant basement. A lot of people will renovate a basement to be a living space. And under various state and local codes, you have to do that by either lowering the floor of your basement or increasing the wall height. And my clients had decided what they wanted to do was have a contractor lift their house up into the air, jack it up, pour a new foundation, and set it back down. That's a pretty significant construction project. And if you were to engage a contractor for that type of work, you would certainly want to find out whether the contractor had done anything like that. Unfortunately, unbeknownst to me, because I was not retained until long after this took place, the gentleman that was hired by my clients had zero experience doing that. And in fact, he was not licensed to perform that type of work. And he also had only ever performed bathroom remodels in the scope of $10,000 to $20,000 worth of work. And unfortunately, my folks ended up hiring him and gave him $500,000 to do something he'd never done before. And when I asked that gentleman in his deposition, which is a testimony under oath, how he learned to lift a house off of its foundation, he told me that he had watched several YouTube videos about it. That's not a qualification that you want in your contractor before you give them $500,000. So my clients in that case wish that they had heeded the second bullet point, which is performing a little more due diligence to find the right contractor for that job. The third cause of most disputes is a lack of involvement, and this one goes both ways. You can have a homeowner who's not involved in their own construction project, and you can also have a contractor who's not involved in their own construction project. From the owner side of things, I typically see a lack of involvement in rental properties. There's certain types of homeowners who own a property at, say, the Oregon coast. They may go out there twice a year to check on the property. It's not necessarily professionally managed as a rental property. They decide to do some work on that property. They give the keys to the house to the contractor. They give the contractor a down payment and they say, great, I'll see you in 6 months. That's not a good idea. If you're going to have any type of construction project, whether it's your roof being put on your house, or it's a complete whole house renovation, or even new construction of a home, you want to be involved as the homeowner. And it's not necessarily going to be fatal to you winning if there's any sort of litigation on the dispute, but certainly I would always prefer my client to have been relatively involved in the process. Now, on the contractor side, most of you will be familiar with the term general contractor. Some of you will also be familiar with a somewhat pejorative term for some general contractors that I and my colleagues will use to describe what is called a paper contractor. And a general contractor, some of them will be very hands-on, and they may not necessarily be, quote unquote, swinging a hammer on the job site, but they're going to be there supervising, exercising quality control, and ensuring that the subcontractors, if there are subcontractors being used on the project, are actually doing what they're supposed to be doing. That's called oversight and quality assurance. And oversight and quality assurance are responsibilities legally of a contractor for all of its subcontractors. You don't get to just get out of jail free because you're a general contractor who hired a subcontractor. You're actually responsible for the work of the subcontractor if you're the general contractor. So I oftentimes see projects fall apart because the general contractor is not there. They don't send a project manager to check on subs. They don't have anybody there taking photographs or checking the boxes to make sure the thing is actually being done correctly. So lack of involvement is something that everybody should try and avoid. Fourth is a mismatch of expectations. And I would say of these four, other than lack of communication, I'll put that first. This should probably be bullet point number 2. And it relates primarily to time and cost. Almost every contractor out there is going to tell you the time it's going to take for them to complete the work. And I typically say, tack on 25% of the time that you're being told and expect them to do it in that amount of time. Same thing goes for money. It is very, very uncommon for construction projects to come in under budget. Nobody should be shocked by this. You're much more likely to engage a contractor to do work for a certain amount of money and then have that contractor come back and tell you, I'm really sorry, Mr. and Mrs. Jones, Mr. and Mr. James, Mrs. and Miss Thompson. It's going to take me a lot longer and it's going to cost a lot more money. you can avoid that dichotomy or separation between your expectations by having clear communications up front. And we're going to talk about some of the key areas that owners and contractors tend to have different expectations. And what I'll remark on here is my opinion is that this disconnect comes from experience and data. And those terms are basically the same thing. A general contractor who's performed 350 bathroom remodels over 30 years is going to have a lot more experience and therefore a lot more data about how this project is likely to unfold. A homeowner who may never have hired a contractor for a large scale construction project, or maybe has only hired one or two contractors for something like that in the past, is working with a smaller data set. And I think that bringing those parties together at the beginning to make sure that expectations are clear is ultimately going to be the best way to avoid any type of dispute down the road. So now we're going to move into what do you actually do if you have a dispute with your contractor? And this is going to be a step-by-step guide, and not to bury the lead, but towards the latter half of my presentation this evening, I'm going to talk to you about one thing that's actually from a chronological standpoint out of order here, and that is, well, how do you get a contractor in the first place? Or more accurately, how do you make sure that that contractor is the right contractor for your job? But I'm going to reserve that to the end and walk you through what I think are the critical steps in handling an actual dispute. So the first step that I have here on the screen is reaching out to the builder. This can sound extremely obvious. A lot of people, myself included, if I have a problem, I will bring it to the person who's causing the problem's attention. But you'd be shocked by the number of people who won't. And what I would encourage people to do is, for lack of a better word, stick up for yourself. If you observe something and you're not sure it's correct, you may not know it's correct. It doesn't hurt to ask. Okay. And I've talked before about communication. And as you go through and are looking at contractors, if you're interviewing contractors, I often recommend when people provide two different bids to me for me to review and a contract from two different firms, and if all those things are roughly equal, go with the person that you feel provides the best communication style that works for you. If you're going to be involved with a contractor for any amount of time, 3 days to put a new roof on, 10 months to build a new house, whatever the case may be, you're developing a relationship with this person. And it's in your best interest and in the contractor's interest to make sure that your communication styles mesh. If you do identify things that are wrong with the work that's being performed, and again, this requires you to be involved, the first thing that you should do is document those problems. And the way that I recommend you document those is primarily through photographs. Almost everybody is walking around with a very high resolution camera in their pocket. It's not a big deal to take that out and take some pictures. And if you have a contractor who's not willing to let you take pictures of the work that they're performing on your property, you should fire that contractor yesterday. There's nothing wrong with taking pictures of the work that your contractor is doing at the time that they're doing it and when they've wrapped up for the day. In fact, when I have a contractor work on my home, I take pictures of their work when they leave. I may never need those pictures, but your future lawyer, if you ever need one, is going to be really happy that you took those pictures. So do take pictures. And if it's not something that you're 100% sure is actually a problem, take a picture of it anyway and ask your contractor. Because remember, you're paying them good money to make sure they do a good job. You're paying them good money. They need to make sure they're doing a good job. And they shouldn't have any problem with you raising a question or asking, hey, Joe, I'm not sure that these pipes look like how they should. Can you explain what's going on here? There's a right way and a wrong way to do that. Okay. And when I say right and wrong way, I mean both style and substance. And we're going to talk about substance first. My biggest caveat here is found in the third bullet point. If you have a problem with your contractor, it's okay to call them, but don't make that the only thing that you do. If you pick up the phone and call them and lodge your concern, and the contractor says, hey, homeowner, I'm going to take care of you. Don't worry about it. That's not good enough. You need to then follow up with an email, or better yet, start with an email that says, hey, contractor, I have some concerns. They are listed here in bullet points to the best of my ability. And don't worry if you're not a contractor. Your contractor knows that. Put it in terms you understand. The shingles look crooked. The gutters seem to be sagging. Any of those things, however you can articulate them best based on your experience, are valid concerns to bring to your builder. So don't be shy about doing that. If you do send a call, take a take a page out of my book as a lawyer. If I have a conversation with a lawyer, I'm going to send them an email right after that says, "Hey, lawyer, here's what we just talked about." Why? Because I don't want that lawyer later saying, "We didn't talk about that." And while I may never be able to prove that we did or didn't talk about that thing, at least I'll have an email sent right after that says, "Here's my understanding of the call. Go ahead and do that too." I think that's completely appropriate, and it's going to save you a lot of headache later and avoid a situation where everybody's pointing the fingers at each other and arguing about something that no one will be able to prove. As far as style goes, be kind, be polite, but be firm. It is not uncommon in my practice to get, when somebody comes into my office, they'll bring with them or send me electronically a set of their emails. And if it's a long-term construction project somewhere over a month, almost inevitably, I'm going to see a trend where the kindness and the politeness starts to go down as the parties continue to communicate. Emails that in January might have been very friendly and turn very cold and callous 6 months later. Do your best to avoid that while at the same time sticking to your position. This looks odd to me. I'm not sure about this. Hey, I just got your invoice. You told me $3,000, but your invoice is $5,000. Why? Every claim in Oregon has a statute of limitations, which means that if you went to get a lawyer and you had waited too long to bring these concerns up, you may not be able to seek recovery of any money that you might have lost in the court system. So it's important that you actually do address these things. And some people aren't confident in doing that. That's okay. You can contact an attorney, you can contact the CCB, and you can get somebody who's actually going to feel a little more comfortable being confrontational. That's okay. But I do recommend that even if you are confronting the contractor about something that you think isn't correct, please do be polite, and please do remember that later I may use your emails as an exhibit in a trial or an arbitration. And I would always prefer that my clients look like they are kind and considerate people so that the contractor can't make them look bad later. The rule that I was taught in law school and that was taught as a young professional is if you send an email, assume that at some point somebody's going to hold it up as an exhibit in a court proceeding. It's a good rule of thumb to stick by because it makes sure that you are being as cool, calm, and collected as possible. Last, I'm going to talk about having a specific ask. Sending an email to your contractor that says, "Hey, this is taking longer than I thought," isn't very helpful to the contractor. It's also not putting your claim, if there ever were to be a formal claim, in the best possible position that it could be in. So instead of saying something like, "I thought this was going to be done a while ago," say, "When we signed a contract, you told me that we would be done by March 1st. It's now March 15th. I would like an explanation by Friday at 5. Thanks." That gives the contractor a really specific task to do. And if the contractor fails that task, it's a really good indication that you're probably not going to be able to resolve this. But at least give them the chance to resolve it by being clear about what it is that you want them to do. Step 2, I always recommend that as a very first step, even in cases where I know the parties are never going to reach an agreement and that the CCB, and we'll talk about them at length, I always recommend that you file a complaint with the Construction Contractors Board, which is what CCB stands for. Every state has an administrative body. Here in Oregon, it's the Construction and Contractors Board. In Washington, it's the Bureau of Labor and Industries. Everybody has an administrative group that regulates contractors. The CCB in Oregon is responsible for, among other things, licensing contractors, providing ongoing education courses for contractors, and serving as a clearinghouse for consumer complaints against the companies that they license. I've got the website listed here on the in the third sub bullet point here, but it's really easy to remember because you can always just go to oregon.gov/CCB, and that will take you to their landing page. The CCB's website is full of great things, and we're going to talk about a few of them. We're also going to talk about a few of the limitations that the CCB has as an enforcement body against contractors. But first, I want to start with what does it mean to contact the CCB? What I mean by that is filing a complaint against the contractor. Now, this is very low cost. Okay, it costs $50 to file a complaint with the construction contractors board. If you file a complaint with them and say somebody took $100,000 from me and then disappeared, that's going to cost you $50 to bring that complaint. If you want to file that in Washington County Court, that's going to cost you anywhere from $283 to $594 to file that complaint, depending on how much it's for. Meaning it's much cheaper to go through the CCB process than it is to jump straight to filing a lawsuit in court. And the CCB is pretty wide open about the types of complaints that you can lodge against a contractor. The CCB may not recognize everything. They may refer you to a different administrative agency. But if you have any type of run-of-the-mill dispute about quality of work, payment, tardiness, timeliness, job site cleanliness, safety, those types of things, those are definitely going to be fielded by the CCB. And you start that process by sending them a notice. Now, this is called the pre-complaint notice requirement. It's a letter, and it's a letter that the homeowner can send without an attorney. You don't need me to send that. And all your letter needs to say is, at the expiration of 30 days, I intend to file a complaint against you with the Oregon Construction Contractors Board. Now, it has to be sent certified mail, and there are forms available on the CCB's website to walk you through this. If you do not provide that notice 30 days before you actually file a complaint with the CCB, your complaint will be rejected. So it is important that you send that notice out. It can be as simple as one sentence. It often is just one sentence, but you have an obligation as a homeowner to notify the contractor before you seek assistance from the CCB formally through a complaint. Once a complaint is actually filed, meaning you've gone through that pre-claim notice requirement, you then printed off some of the forms from the CCB that ask you to describe the dispute, or you've had an attorney do that. What's going to happen next? Well, the next step is that the CCB is going to assign what's called a dispute resolution analyst, which is a very cool term for a mediator. And that's going to be a CCB employee who is going to then schedule either an in-person or a telephone mediation. There are different mediators who handle it differently, and I have participated in many CCB mediations. And what they do is they either go to the project and meet with the contractor and the owner, and those people are kept separate during those mediations. A lot of the time, the contractor will be outside in a truck, sitting on the porch. The homeowner will be inside the house. And then the mediator will go back and forth between those parties to try and resolve the dispute. And the way that the mediator or dispute resolution analyst is going to do that is by asking first the homeowner what it is that they want. Now, some CCB complaints seek money. We overpaid our contractor. He charged us too much, so we want $5,000 back. We're going to look at some examples of CCB settlement agreements in a moment. But most of the time, it's a complaint about the type of work that's being performed, either that it's been performed incorrectly, or it's been performed too slowly, or that it wasn't performed at all but has been paid for. In those cases, most oftentimes, the CCB mediator is going to try and convince, or will just ask the contractor if he or she is willing to do the things that the homeowner is asking them to do. If the contractor is willing to do that, either perform some additional work, correct work, or pay them money back, then the CCB mediator will celebrate because he or she will have resolved that dispute, and he or she will generate a settlement agreement on the spot for the parties to sign. However, many times a CCB mediation is not successful. The main reason for that is that the CCB is not authorized, nor is it intended to be an enforcement arm of homeowners. The CCB can attempt to mediate a dispute, but generally it's not going to be in a position to compel action on the part of the contractor. This is known as a voluntary process. Either party can walk away at any point, and ultimately many folks who end up in my office have already been through this process and it didn't help them. However, if you think back 5 minutes ago, I said I always encourage people to use this process. Well, Nels, why would you encourage your own clients to go through a process that, albeit is only $50, but ultimately probably isn't going to resolve that for them? The reason for that is found in the last bullet point on this slide. It says that an active CCB complaint is required to access a contractor's bond. And here I want to briefly pause and give you a 2-minute education on how the state of Oregon protects homeowners financially from contractors who mess up. And the way that they do that is through two financial requirements to be licensed as a contractor. In Oregon, you have to provide proof of liability insurance. Liability insurance protects the contractor from claims made by other parties. It's not for the contractor making a claim like your car insurance or the home insurance. That's first party insurance. This is third party liability insurance. And you're required to have that insurance to be licensed by the CCB. So that's potential money that is available to somebody who makes a claim against a contractor. It's not the same as getting the actual assets of the company. And frankly, in my opinion, having sued a lot of contractors, many of them don't have a lot of cash assets. Somebody who does home remodeling might have a truck. The truck might be titled in his mom's name, may not have cash, may not have other equipment. A lot of contractors are purchasing materials, not with cash, but on credit or with homeowner cash that they're using to front for the material purchase and then seek reimbursement. And we have an insurance requirement in Oregon that's designed to fill the gap. If a contractor screws up, then potentially that liability insurance company can pay the homeowner for any damages they might have suffered. However, we impose a second requirement, and this is what is called the bond. And a bond is an amount of money that's placed with a financial institution called a surety, and that surety holds that money in essentially what is an escrow account. For those of you who are familiar with that, bond is where the contractor puts up a portion of the money, and then the financial institution fronts the rest. Oregon is a regulatory administrative body bonding state, which means that homeowners have no right to access the contractor's bond. It's actually the CCB that makes the claim on the bond on behalf of the homeowners. And one of our rules in Oregon is that if you have not filed a claim with the CCB and you want to use the contractor's bond to satisfy what is known as a judgment, which is an order from a court requiring a defendant to pay money, then the bond can be accessed. But if and only if the homeowner has not only made a CCB claim, but has maintained an active CCB claim throughout the litigation process. If you think about making a CCB complaint as one side of the train track in a circuit court action, such as Washington County Circuit Court, those can run parallel. They're not going to cross over. But let's say you win in court and you've sued somebody for $20,000 for messing up your plumbing and you win. Well, the contractor may say, I don't have $20,000. Sorry. And at that point, what you have in your judgment is a very, very nice piece of paper. It's not money. You can't take a judgment and put it to an ATM. But what you can do is you can take that judgment and you can send it to the CCB and say, hey, CCB, remember when I filed a complaint? Turns out I won. I want you to go get that bond. And then the CCB will actually send the judgment to the surety. The surety will issue the money to the CCB, and that money will go to the owner. Oregon has a $20,000 bonding requirement, which means that contractors have to show proof that they have at least $20,000 in bond available at all times. However, it's a claims made, get in line first process. So if there are 5 other homeowners who are making a claim against that bond can be gone by the time that you get to it. So it's important to not waste time in either consulting an attorney or making your own claim in order to get that bond. I say all of that because one of the big reasons, therefore, that I would encourage people to file CCB claims with a contractor if they have a dispute is because at the very least, it can be your golden ticket to getting some money through the bond. And I clicked too far, excuse me. Okay, now, if you file a CCB complaint, I mentioned that they're going to set up a mediation. We talked about this a little bit, that it's voluntary. Anybody can walk out at any time. The CCB mediator is not going to be upset. In fact, this week I handled a CCB mediation where the contractor simply didn't show up. That's unfortunate, but okay, it does happen. And what happens if there is a settlement is very different from what happens if there's not. So if both sides agree and the contractor, for example, says, you know what, I messed up. I'm really sorry. I'm going to get in there. I'm going to level your floors. I'm not going to charge you anything. And I'll have it done within the next 30 days. They're going to have to sign their name to all of those promises before the CCB mediator lets them walk away. However, if they say, no, I think that this is right, I'm not going to walk away from, or I'm not going to give you anything, then the homeowner is going to be told through a letter from the CCB that they tried, but they couldn't resolve the dispute. And now the homeowner needs to file a lawsuit. Enforcement of that CCB settlement agreement, if everything works out, can be a little difficult. And I want to talk to you about what a CCB settlement might look like. This is a CCB settlement agreement that I was not involved in negotiating. This was actually this was brought to me a few weeks ago, actually, as you can see on the date here, October 27th. These homeowners, and I've removed any names or identifying things, but in this case, the CCB went to a settlement mediation with the homeowner because there had been some defective work, or the homeowner believed that there had been some defective work. But the contractor was willing to fix it. And here's the problem. If you want to read through this, you can. But what I'll tell you is that it's very vague. Okay, I'm going to read a portion of this. This was written by a CCB mediator. Respondent, who is always the contractor, shall return to the construction site following inspection analysis by a licensed qualified subcontractor and or employees to address any all remediation repair indicated by analysis for the following items. And then it goes on to list some areas of the home that weren't up to snuff. The problem that I had when this person brought this to me was that I, somebody who's done construction law for a decade, have no idea what the sentence that follows both parties agree even means. I don't know what they're talking about when they say inspection analysis. Inspection by whom? Well, they say a licensed qualified subcontractor. Any subcontractor or the general contractor's subcontractor and or an employee. Who's an employee? The general contractors? My employee? What does that even mean? The reason that I'm showing you this is because this settlement agreement is very broad and, in my opinion, very poorly worded. Also, if you look at the very bottom, which you will see, it says in big letters, this agreement is not a substituted contract. Uh-oh. If this agreement is breached by the respondent, the contractor, through no fault of the complainant, the homeowner, then this agreement shall be extinguished as if it never existed. Okay, that's tough because what this means is that the homeowner, if the contractor breaches this, doesn't perform all of this work by Friday, October 27th, and I will leave you a spoiler, they did not complete this work by October 27th, then I, as the attorney, have no right to go to the court and say, hey, we have a signed settlement agreement from the CCB, and they broke it. Because it says, if this is broken, it never existed. That's not particularly helpful. And so I'm not here to rag on the CCB. I'm not here to say bad things about the CCB, but I will tell you that is if this is the outcome of your mediated settlement, you basically don't have a settlement. This is far too broad for any attorney to do anything. I'm going to show you another example and contrast these. This one was from several years ago, and this one I was involved in. And in this, the contractor agreed to send $20,800 to the homeowner no later than May 5th, 2022. That is cut and dry, isn't it? They got to send a check for $20,800. Well, that's great. If I have one of those silly sentences that says I can't do anything if they breach this, then I'm out of luck. But if you look down, it says this agreement is a substituted contract and replaces all prior contractual agreements between the parties, which is awesome and very different from what we saw here. It's not a substituted contract. This is a substituted contract, which meant that instead of filing a lawsuit on this one on your screen that goes back to the party's original contract, I simply had to file a complaint for $20,800 in circuit court and attach this settlement agreement as a copy of the contract. That was an open and shut case. My clients were paid in full. So I would strongly encourage that if you get to the point where you're having the CCB come to your house and set up a settlement agreement, it's probably worth it to get a lawyer to be there too, because I wasn't here for this part. If I was, I would never have let my client agree to that. I would much rather see this length, which is why I show you the difference. That is the kind of thing that makes these settlement agreements tough to enforce. So be prepared that even if you reach a settlement with your contractor through the CCB, and even if you get a signed agreement, they might break that agreement and you might have to go back to your original contract for your rights to be enforced. It really depends on how the mediation goes. Now, what happens if the CCB doesn't resolve my issues? Now, I'm obviously very biased in my data because you don't come to my office if the CCB resolved all of your issues. If the CCB resolves all of your issues, you don't need me. And my hope for all of you on this call or watching this later is that you never need me. I want you to be able to resolve these disputes on your own. However, there are times where that doesn't happen. What do you do in those cases? Contractor's insurance. As I stated before, your contractor's obligated by law to carry liability insurance. And conveniently for you, if you go to oregon.gov/CCB and you put in the contractor's name or license number, you will be able to see who their insurance company is. In fact, you'll be able to see who their insurance company was 10 years ago. And you'll also be able to see their policy and their policy number. And you'll be able to see the limits of their insurance. It's usually $1 million. Some people get more. Some contractors, specialty contractors, can get away with less. But most of the time we see $1 million. And if you can find that information, well, guess what? You can get in touch with those people. I like to make the analogy to if every driver in Oregon had their auto insurance listed along with their driver's license number on a big database. And if you got hit and run by somebody and saw their license plate, you could still find out who their insurance company is. Well, the state of Oregon requires all that information to be publicly available for contractors. And I've had homeowners come to me and say, you know, the guy's become non-responsive. I can't get in touch with my contractor. Well, you know who I know would love to hear that? Their insurance company. Because what you want to do as a homeowner is to be able to create a scenario where there is risk to the contractor if they don't do what it is you want them to do. Now, hear me clearly. I'm not advocating that you threaten a contractor. You should never do that. But it is certainly within your legal rights to look up their insurance company and send them an email that says, hey, you're insured, and that's the term for the contractor in that context. Your insured contractor has damaged my property. I'd like to make a claim. And that's exactly why contractors have insurance, because they know that somebody can make a claim against them. And that liability insurance is subject to all manner of exclusions. And I could talk for a week about insurance coverage for contractors, but at least make a claim, particularly if the CCB is not resolving the issue. Most of the time, not most of the time, all of the time, the CCB is just going to list their insurance company. You can search, think of a big one to pick on, Atlantic Casualty Insurance Company, ACIC, insures a lot of contractors in Oregon. You can Google ACIC email claims, and you can find their email address. Include the policy number, which is on the CCB website, and describe the problem, and congratulations, you'll have opened a claim. And one of the things that's important to remember about liability insurance for contractors is that every single one of those policies includes a duty to cooperate provision. And a duty to cooperate provision requires that the contractor does what their insurance company says. And the insurance company also holds the money. So if you're looking to get money out of your contractor, you're going to have a lot better chance of getting it from their insurance company, not necessarily from them individually. We already talked about the third bullet point that you still need an active complaint to collect on a contractor's bond. So do make sure that you have actually filed a complaint before you try and file a lawsuit. And if you need to file a CCB claim after you filed a lawsuit, you can do that, but I recommend you speak to an attorney. Also, don't hesitate to reach out to an attorney generally if you go through the CCB mediation process. I'd say it's probably 50-50, the clients who, or potential clients who come to me and say, hey, look, do I hire your law firm now to represent me, or do I wait until I do the CCB thing? You don't need me there. It'd be good if I was there, but you absolutely don't need me there. So why don't you try that process yourself? And if it doesn't resolve, get back to me. If it does resolve for you, then great. You haven't wasted money on yet another blood-sucking lawyer. All the better for you. Now, this is where I want to go back in time to before you even hired a contractor. And then I'm going to make sure that I wrap my comments up in the next 9 or so minutes so we have time for any questions and people can get on with their evening. But this is maybe the most important part of my presentation is how to avoid a dispute with your contractor before it arises. Now, the main things that I want you to focus on is treating any transaction with a contractor like any other large scale purchase, because that's what it is. And you'd be pretty surprised to find out how many people make large scale home purchases, meaning a construction project, by doing less research than they might do on Amazon for buying a new vacuum cleaner. I have people come into my office all the time who say, when I ask them, well, how did you pick this contractor? And they say, well, they did good work for my friend. So you gave them $1 million or you gave them $50,000. If my friend recommends a pizza restaurant, I'm probably going to go look at the menu before I even go to the pizza restaurant. And that's just for a slice of pizza. So think about the cost and think about whether or not you've done enough research in light of that cost. Let's start with the CCB. It's an excellent database. As I mentioned before, it contains a trove of information about contractors. It also includes, in addition to the insurance that we've been discussing, it includes a list of CCB claims that have been made against that contract. You're not going to be able to see a whole lot of detail about those claims. But if you enter in a contractor on the CCB website, then you can actually look at their complaint history and you can see a list of how many complaints were made, what the type of complaint was, and what, if any, resolution there was. And you'll usually see a note on those entries that say something like settled through mediation or unable to settle, claim filed in circuit court. I also recommend that you use review websites. Now, this is a bit of a mixed bag, and if any of you are contractors, you're probably gnashing your teeth because contractors don't generally love review websites because one bad review can have some bad effects for that company. But your Yelps, your Google reviews, your Angie's List, there's a bunch of those websites. Check out your contractor, see the reviews. Don't think of this as a small thing to do just because you got a friend. Look, I understand how annoying and hard it is to shop around for contractors, but at the very least, instead of shopping around, let's say you're really sure you want to go with, Jim Handyman. Check out Jim Handyman on the CCB website. Find out if he has complaints. Okay. You can even, if you want, get access in person at our courts in Washington County, Multnomah County, Clackamas County. You can look up contractors by name as defendants in civil lawsuits. I do that online for my clients all the time as a way to vet contractors. And if you go and find out that that really cheap roofer who you really liked, but you're not sure about, has 15 lawsuits filed against them, it's a pretty big red flag and you should walk away. But a lot of people don't take advantage of the internet and what it has to offer in terms of research. Number two, once you've identified a contractor, get a contract. I'm going to say that again slowly. Get a contract. You need a written contract for the construction work that is being performed at your house. I do not care if it is somebody switching out a $10 light switch. You need a contract. A contract can be a work order that you sign. That can be a contract. But please, get it in writing. You need a scope of work and you need a price. And you need signatures. Get a contract. If you get a contract, great. Read it. A lot of people call me and say, oh, Nels, I have a contract. Do you know what it says? Well, I didn't read that thing. Why not? I'm not a lawyer. Why didn't you get a lawyer? Lawyers are expensive. Well, it's about to get way more expensive because you didn't read a contract and now you need somebody to fix this. Contracts should be written in a way that you can understand. If you don't understand a contract that your contractor is putting in front of you, ask them for an explanation. If you don't like the explanation, walk away because it's not worth it. Don't sign contracts like everybody does for their internet and phone and 50,000 other things that are 40 pages longer. If your contractor gives you a 50-page contract in tiny type that looks like a book, you should walk away. That's my strong advice because a good contractor is going to make it so that you can understand it. It benefits them to have you understand it as well as themselves. Again, ask questions. Make sure your contractor is aware that you are a cognizant person who can read. And if you're not, get someone to help you because a contractor who believes nobody's looking over their shoulder is more inclined to make a mess of your house. So avoid that problem, avoid that dispute, please, by actually asking your contractor about the contract. And if the contractor is not willing to answer your questions, I've had this come up before. Hey, Nels, can you look at this contractor or look at this contract? And then I reach out to the builder and say, hey, builder, I'm a nice guy. You're not in trouble, but I am a lawyer. I had some questions about your contract. And they say, well, I've used that contract for years. I'm not going to have a conversation about it. Well, then you're not going to get my client's money because we don't work with people like that. You have as much power, if not more power, as a homeowner. Remember, the money is flowing that way. You're not being paid by the contractor, you're paying them. And as such, you have every right to ask questions about their contracts. We already talked about this a little bit, so I'm going to be brief. We talked about using the CCB to confirm your license, confirm they're insured, confirm that they're bond and that there haven't been bond claims. You can look online at those other private websites. You can go to the courthouse and look them up. You can call me, hire me, I'll vet your contractor. Ask your contractor for a referral list and then call them. That's the part that I think a lot of people forget, which is they'll say, hey, can I have a referral or a list of people to talk to? And the contractor sends you some cherry picked list of other people they've done work for. You're supposed to then call those people. This is not the same as saying, show me a bunch of positive reviews. You actually want to talk to people who also had Dan do their kitchen or Brian do their basement. Find out from those former Brian and Dan clients what they thought of Dan and Brian. Okay. It is work, it is time, but trust me, you will save yourself a lot of pain and cost later if you do those things. Lastly, seek legal review for a contract. I already told you that I hope none of you ever need to call me. Okay, so this is not me plugging my own business. But what I will say is that even if an attorney is going to charge you $5,000 to review a $100,000 contract, that's 5% of the contract price. That $5,000, if it avoids a $50,000 lawsuit later, has provided 10 times its value on the back end. And certainly there are a lot of good construction attorneys in the Portland metro area who would happily review contracts before you sign them. The most common question I get at the end of a lawsuit from my client, the homeowner, is, Nels, how could we have avoided this? My answer, although somewhat self-serving, is you should have called me a year ago or 2 years ago or whatever the case may be. People are very hesitant because they think lawyers are really expensive. I'm not going to argue that we're cheap, but what I will tell you is that there's value at times in having an attorney who understands contracts and specifically construction contracts review these kind of things. Last thing I want to talk about, and then I really am going to wrap up and leave time for questions, is some notes about reading contracts, because you heard me emphasize to the point of belligerence that you should read your contract. Everybody now knows how strong of a believer I am in that. Well, what should you be looking for, Nels? What are the things that you would be looking for? What are you looking for when you open one of these contracts? Well, good contracts are going to be written in a way that you can understand. I put good in quotation marks because everybody believes that their contract should be in their favor, right? Contractors always want the strongest provisions. And I'll be honest, I write contracts for contractors too. I don't rep them in litigation, but I write contracts for them. Oh, Nels, make this the best contract for me. Well, if I do that, if I dump everything into one end and make everything pro contractor, or if the shoe is on the other foot, make everything pro homeowner, the other side's never going to sign it. And ultimately, what good lawyers try and do is to write a contract that is easy to understand and fair. That's what I mean when I say good. Make it a fair contract so that everybody understands. A good contract is one that's enforceable if it needs to be enforced and that the parties understand. A contract is generally defined as being a meeting of the minds or a mutual manifestation of a shared intent. I want you to build a roof. I want to put a roof on your house. I want to pay you $15,000. I want you to pay me $15,000. You got a contract. That's how contracts should be, fair and even handed. And it should be a memorialization of what both sides want. I already talked about making sure you ask, so I'll be brief. You're the customer, okay? You wouldn't go to a restaurant if you couldn't stand cheese and you heard that they had a great quiche. Are you going to ask if there's cheese in it? Probably. You don't like cheese. So ask your contractor, say, look, I really don't want beveled edges on this stair stringer. Okay, well, we won't do that then. The contractor doesn't know what to do unless you understand or you point out that you don't understand. Okay, it's totally okay to ask them questions. The key provisions that you should be looking at, and this is going to be make people uncomfortable because they're like, I'm not a lawyer, but again, good contracts should be written in a way you can understand. Most important, payment procedures. That causes more lawsuits than any other part of the contract. How are they supposed to get paid? The biggest one is down payments, late fees, and interest. I won't bore people with all the horrible contract provisions that we've seen, but I will point out that you should probably have pretty clear understanding before you give somebody a large amount of money about what they are expected to do. So make sure that you do that before you make a down payment or a security deposit on any type of construction work. Late fees and interest are unfortunately a reality that if you make a late payment, and I have seen, and hopefully this shocks a few people. I read a contract for a client a few months ago where the contractor included a provision that said any amounts that are received more than 30 days after invoicing shall be subject to a penalty of 90% interest compounded monthly. I said 90%, not 9%, 90%. Now, that is patently probably unenforceable as usury, which is unlawful interest in Oregon. But you'd have better chance having the mafia give you a loan than getting a contractor to do 90% interest. But people will try and cram that into contracts, so be aware. Dispute resolution provisions are the kind of things that describe what the parties are going to do if there is a problem. The most common dispute resolution provision is a provision that says you don't get to go to court if you're going to sue the other side. Instead, you have to go to arbitration. You should be aware if that provision is in your contract. Good contractors are going to underline and put that in bold because you are waiving your right to have your case heard before a jury. Those types of provisions can have varying degrees of enforcement. So if you have one in there and you have questions, consult an attorney, or at the very least, ask your contractor. The last one is limitation of liability. You see this a lot I've seen it most commonly in home inspections, which is separate from the CCB in terms of licensing, but it's still really common to see this. And a limitation on liability or liability as relates to damages is actually putting a cap on the dollar amount that you can recover, or it's actually making you waive your ability to recover certain damages. The most common things that are waived in a contract for construction are loss of use. So if you run a hotel and you hire a company to replace the windows, and your contract says you don't get to claim loss of use if we screw up, well, you're not going to get your lost rents. That's loss of use. You might get the cost to repair the windows, but you're not going to get any of those subsequent damages that flow from that. I also see caps on the amount of money that you can claim, including the cap on the amount of services rendered. So if you hired a contractor to do $1,000 worth of work, and that $1,000 worth of work turns up to a $100,000 problem, you're going to have a really hard pill to swallow if your contract says any damages are limited to the dollar amount paid for in this contract. So there's again a big topic that could be discussed for a long time about contracts and some specific provisions. But look at how people get paid. Look at the provision about what happens if there's a disagreement, and look for any limitation on liability or on damages. That's going to do it for me in terms of my prepared comments. Again, I'm Nels Volin at Volin Wilkinson. That's my contact information. We're located over Northeast Portland. If anybody wants to stop by, say hi on the east side. But shoot me an email, give me a call, check out our website. We are available to answer questions. And yeah, I want to plug our next year in a series of these wonderful Now What seminars coming up in February. Paul Lemieux and Meredith Williamson from Northwest Estate are going to talk about wills and trusts. So you want to make one. Now what? Later in March, Mia Getlin from Mia's firm is going to talk about cannabis businesses. You want to start one. Now what? Those are great topics. You can always check out the Washington County Law Library's website. They have a page dedicated to this series. That information is on the bottom of your screen. I'm going to go ahead and end my share here. What will that do to our screen? Okay, excellent. Now I'm going to pull up the Q&A. I don't see any open questions, but I'm going to allow anybody, if you want to chime in, ask one, or if Amy, you want to facilitate any of that. I'm all wrapped up. I hope you found this illuminating. I hope it wasn't over anybody's head. I know that I talk very quickly. A number of Washington County judges have told me to slow down, please, Mr. Volin, but a lot of info into an hour. And again, you can always reach out to me. I'm happy to answer questions about tonight's presentation. Amy, did you have anything you wanted to add?
I just wanted to say thanks so much for all of that valuable information. That was awesome. I am going to stop the record, and if people want to ask any questions, you can feel free to do so. Otherwise, thank you so much for joining us tonight.